Welcome to another edition of From the Front Lines, how real estate managers are addressing COVID-19. Our topic today is commercial lease negotiations. I'm here with Randy Airst, CEO of Exceedant, a commercial real estate advisory firm. Randy will be sharing information from his series of courses on COVID-19 and lease negotiations, available at covid19rent.com. Randy, should property managers be prepared to negotiate lease terms right now?
Well, today, unfortunately, we're in an environment where a significant number of tenants are in arrears on their obligations. Even if they're not currently in arrears, they may be experiencing some cash flow difficulties, some liquidity problems, and it's a prudent idea for property managers to anticipate those problems, stay in close contact with the tenants, and be prepared to negotiate so that you don't have for example, a short-term liquidity problem that could evolve into something much more serious.
I see. And can you talk a little bit about typical negotiation styles?
The two basic styles are hard and soft. So for example, on the hard side, you've got a negotiator that is focused, laser focused on results. To the exclusion of, for example, the relationship. So they'll be positional in nature. So the individual will say, well, the rent is $50 a foot. The relationship will not be a consideration. On the other, that's an extreme on one side. Then you've got the soft negotiator who's intently focused on the relationship and is willing to make concessions in order to further the relationship, setting aside the substance.
And so why would a property manager be willing to negotiate right now with tenants?
Because right now, the landlords need the tenants as much as the tenants need the landlords. If you've got, just by way of example, a fantastic development in the Hudson Yards, great tenants, people like Coach, Neiman Marcus, Rolex, Yves Saint Laurent, and just top-of-the-line tenants. The landlord, the related company, announced in April that 75% of the tenants had not paid the rent. So the reason property managers should be negotiating is, number one, there's a significant number of tenants that are not paying the rent. Just by another example, Boston, big, the Boston group, big real estate REIT, they've only collected the retail rent on 23% of the tenants. Now, office may be higher, residential will be higher than that, but still, you've got a much higher incidence than is normal of tenants not paying rent. Not only they're not paying, but if you've got a tenant, again, that's experiencing a liquidity problem, you don't want that to grow into something much more substantial. And I think it's important to point out that the landlord's interests are the same in many instances as the tenant's interest. The tenant interest will be to be a good rent-paying, contractually fulfilling tenant, and the landlord wants that tenant there for a sustained period. That's how property owners generate wealth, passive recurring income. So it's not necessarily the most prudent thing to push a tenant, collect May, June, July rent, then leave in the position, the tenant in the position of being insolvent on a longer term basis. So it's good to open up those lines of communication, find out where the tenant is, what problems they're experiencing, and see what can be done to further the parties' interests where they coincide.
Randy, can you explain objective criteria and what role it plays in negotiations?
If you take a look at the different criteria that can be applied, a lot of them will be subjective. So they'll be, the landlord will have their opinion, the property manager will have their opinion. Similarly, the tenant will come at it from their own perspective. Objective criteria means you're selecting criteria established by an independent, objective third party. So just by way of example, in New York, the Real Estate Board, REVNY, they've got a criteria for measuring property. That's one criteria. Another criteria for measuring property will be BOMA, another criteria. But in both instances, they're objective criteria independent of the property manager's opinion or the landlord's opinion or the tenant's opinion. So when you bring those objective criteria to bear, you stand a very good chance of separating the people from the problem. So you don't have, there's any number of criteria that can be applied to resolve these issues. But by selecting objective criteria, not bringing it down, well, in my opinion, the rent should be this. It's nice to say, well, look, here's a similar property, here's a shopping center or an office building or an apartment or whatever the case may be, and here's the fair market value. So that's just another example of fair criteria. So it's a much more equitable way to resolve a difference of opinion.
So how will a property manager know if they've negotiated a prudent agreement? What should they be looking for?
Three different criteria can be helpful. Number one, does it serve the party's interest? Does it further the party's interest? So that presupposes that the property manager, prior to engaging in negotiation, is going to ascertain, one, their own interests. Does it satisfy those interests? Two, the other party's interests, because you can't have an effective agreement without satisfying the other party's interests. Number two, is it efficient? So one reason that we like the merit-based system is it's more efficient than positional. So positional bargainers typically go in and they might start high, and over a protracted period of time, they'll begrudgingly go down incrementally. So efficient means, you're not necessarily getting the attorneys involved at potentially great expenditure. You're not taking extreme positions. So it's an efficient process. And number three, are you improving the relationship? Unfortunately, through the years, a lot of landlord-tenant relationships are a zero-sum game where, the parties perhaps don't pay enough attention to the relationship, but with an improved relationship, particularly in this environment, there's an opportunity to expand the pie. You're not necessarily dealing with a zero-sum game, so you don't have to go into it and say, well, if I negotiate, the landlords and property manager might say, if we negotiate a $5 square foot concession, we're losing by our $5, they're gaining $5. There's opportunities to enlarge the pie. One example of that, let's take retail, would be if the tenant were willing to forego a co-tenancy provision. With a company like J.C. Penney, they're going to be closing hundreds of stores. That's a valuable concession for a property manager to extract, because it means that the tenant can't go to an alternative rent and can't terminate the lease typically after a 1-year period of time. And for an office tenant, it might be, okay, we're going to provide you with several months of abatement, but because you have a shorter-term liquidity problem, but we're going to ink you to an extension. So on a long-term basis, if the landlord and property manager calculate how much they're saving, what are the costs? We're not paying a broker for a new tenant. We're not paying legal fees to negotiate a new lease. We're not paying tenant improvement allowance, which even in New York are averaging in some of the submarkets 14 months. We're not giving out free rent, the time between the lease commencement date and the rent commencement date. So we're saving an awful lot of money in relation to what we would be spending if, we put the hammer down. Maybe we collect a few months of extra rent, but what are we foregoing?
And why should property managers separate the people from the problem, so to speak?
They're two different things. If the property manager has an objective, undertaking the negotiation on behalf of the landlord, and the tenant has an objective. By attacking the problem, there's the possibility that the property manager working with the tenant can come up with a solution that satisfies both parties' interests. But if it's personalized, if it's the tenant being attacked or the property manager being attacked, the chances are much slimmer that they're going to be sit down and looking at it in a collaborative manner. I know it seems counterintuitive, but real estate leases are so complex and go so far beyond the base rent for office, for retail, for industrial. There's an awful lot of ways to expand the pie, particularly in this environment where the property manager really doesn't want the space back. This is not a situation where there's a rising market and the property manager could say, you know what, the lease that I'm looking at says $50 a square foot, but the current market is $60 a square foot. So I'm really not concerned about taking the space back. In fact, I'd be doing my job and fulfilling my fiduciary duty if I get the space back when the tenant is in default of their lease obligations. So by attacking the problem, the problem is in many instances a short-term liquidity problem triggered by social distancing and mandated closures by municipal and state governments. By attacking the problem, you're standing a much better chance of satisfying, the property manager will be satisfying his or her client's interest, the owner of the property or the investors, and also satisfying the tenant's problem, because I think one thing worth mentioning is without satisfying the other side's interests, you can't satisfy your own interests. You want the other party to get what they want. If a tenant is experiencing a 2 or 3 month liquidity problem, you want them to be able to solve that problem. And you also want to, at the same time, involve the other stakeholders, because obviously folks like lenders, franchisors, guarantors need to be part of the process. And again, back to your question, Suzanne, when you're attacking the parties, particularly in multi-party negotiations, it becomes untenable and that much more difficult to satisfy the interests of a broad array of parties.
And along those lines, what are some tools that property managers can use to increase value for themselves, their clients, and their tenants?
One way is the one that I referenced before is co-tenancy, for example. If you're a retail property manager and you're in a mall where JCPenney is closing, for example, or another anchor, the landlord is in a tenuous position. A lot of properties financed with commercial mortgage-backed securities have a situation where if an anchor closes, a specialty servicer can be brought in. That you can further your client's interests as a property manager by eliminating those co-tenancy provisions, because they can be very costly. A tenant in many instances can go from fixed minimum rent of whatever the case may be to an alternative rent, which is a percentage of sales. And with social distancing, sales are going to be down dramatically. Similarly, if you've got an office tenant and their lease may be coming due and they need some short-term relief, if you can do a blend and extend to them some short-term relief if they need it, if they establish that it's required, and they've pursued all other available means of securing the funds that they need to fulfill their obligations, then you're gaining much more than you're losing. Because what you don't want to do is, in this type of environment, have to go out there and market an empty space. Spend good money after bad pursuing a debt from a tenant. If you can ascertain to your reasonable satisfaction that the tenant is viable in the medium and in the long term. Why not get them over that hump and retain them rather than go and expending all those resources that you will have to in order to compete for a new tenant. And it will be a competition with an awful lot of landlords in various asset classes indicating that they will provide concessions in order to sign new tenants.
Always harder to find a new tenant than retain an existing one, right?
Absolutely.
Randy, how would managers trade items of unequal value?
If by sitting down before the negotiations begin, looking at the other side's interest, in a lot of cases, what the cost to a property manager and his or her client could be substantially less than the benefits you're conferring. Not all things are created equal. So by way of example, it may be very valuable to a landlord to have a more restrictive assignment clause. So for example, tenant is looking for an extension at a relatively modest rate compared to what rents may have been 6 months ago before COVID hit. The landlord may be agreeable to providing that type of concession, but won't want the tenant to act as a landlord profiting from the current economic malaise. So they won't, if the rent is 50 and then 2 years down the road rent is 70. The landlord may say, I'm willing to provide you with this benefit. I'm not interested in putting you in the property management or the landlording business where you're collecting that gap of 20. So they can insert a profit-sharing provision into the lease, ensuring that the tenant's not going to pick up their 20, which the landlord and their property manager may feel rightfully belongs on the landlord side of the ledger. So that way, it doesn't, the current market may be at the 50 level, so it's not really costing the landlord anything to do that. In fact, they're saving because they're not out there chasing a new tenant and incurring all those expenses that we spoke about. But they're able to pull it back and ensure that they're not giving away that saving to the tenant, where they can cash in a couple of years down the road, where rents will probably have recovered and could be substantially higher than they are today. So they're not really giving up much at all because the current market may be 50, and in fact they're saving, but they're pulling back something that could be invaluable to them. You don't want those situations where the landlord has to pay a significant amount to buy out a lease. There was just in the Penn campus owned by Vornado, a significant office and retail REIT focused on New York City. They had to buy out at many millions of dollars a Kmart office lease. It was either at Penn 1 or Penn 2 right near Madison Square Garden. They had to pay many millions of dollars off of an old lease. It wasn't a sublease, but it's a kind of situation where, a tenant right now might say, I want it for as long as possible, as cheap as possible. But again, you can claw back parts of that, for example, with a take-back provision. Okay, if you ever ask us for a sublease, we have the right to take the space back. So there's, real estate doesn't have to be a zero-sum game. There's, and property managers play at a very sophisticated level, so it's possible for them to grant concessions when they're reasonable, ethical, legitimate, and in the tenant's interest, and not harmful to the landlord, but also to further their own interest. And the tenant may say, you know what, at this juncture, I don't care. I want the extended lease at that rate for my own purposes, and I can agree that I'm leveraging the current situation in order to get a good deal. And I concur that if we're 2, 3, 4 years down the road, I shouldn't be able to take advantage of something that happened in the spring of 2020 in order to cash in.
And lastly, Randy, what is BATNA and how can it be applied by managers right now?
BATNA is the best alternative to a negotiated agreement. So the only reason to negotiate is to improve your circumstance. If you can't improve your circumstance with negotiation, and we spoke early on, we spoke about those three different criteria, and one of them is, you want the other side to satisfy their interests. You also want to satisfy your interests. So BATNA, for example, would mean the landlord can enter negotiations with a tenant, seeking some type of amendment from the lease. The landlord needs to know, if these negotiations don't bear fruit, if we can't arrive at an agreement, what am I going to do? So, in many instances, the landlord and the property manager will, bring an attorney in, have the lease reviewed to determine, for example, if the force majeure provisions apply. Force majeure, means a force greater than. In many instances, the tenant will be saying, the force majeure relieves me of the obligation to pay rent. The landlord, in many instances, will, differ, will have solicited an attorney's opinion, which will differ from that held by the tenant. So that's a BATNA. So the landlord knows going in, and they'll also have, in addition to BATNA, they'll know a minimum, resolution. They'll have in their mind, basically, be keeping an open mind in case another solution presents itself. But here's what I'm willing to do. Here's what I'm not willing to do. If I can't achieve this basic level of result, then I'm going to serve a notice of default, and we're going to proceed to try to retake possession and enforce the provisions of the contract. But in other words, always go in knowing what your BATNA is, and then the second and third follow-up to that is try to improve your BATNA. Number three, try to worsen the other party's BATNA. What I mean by that is, if a property manager representing their client in a particular negotiation confronts a tenant who says, I spoke to, my attorney tells me X, Y, and Z, and that because of the force majeure provision or impossibility or frustration of purpose or any one of those other provisions, I don't have to pay the rent. The property manager can then, again, going back to objective criteria, pull out the cases and say, well, you know what, we've also consulted with counsel, and here are the cases that we believe apply in this jurisdiction. So we're going to try to work something out. We value your tenancy and the relationship, but we believe that the rent continues to accrue, and we're basing that on objective criteria, and if need be, we're going to, we can rely on those criteria. But that having been said, let's try to work something out. So that would be in many cases for a property manager and landlord, the BATNA would be the legal system.
Thank you so much, Randy. This is really helpful information as managers go back to the drawing board, so to speak, on some of these leases. Please continue to visit irem.org, where you'll find our page dedicated to providing updates and resources to support real estate managers in making informed decisions during this time. That's irem.org.